everyone. Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Welcome to the show. Louisiana is unique in that it sends more drug and nonviolent offenders to prison than the national average. In 2010 and 2011, about 1,300 first and second-time offenders were given jail time in Louisiana for possession or possession with intent to distribute a controlled, dangerous substance. Now, that's according to information released from the governor's office. It is a big problem in our state and across the country. And today, we are continuing our conversation about how the justice system deals with drug offenses and offenders. And we are happy to welcome Attorney Joe Marino back to the show. But first, John, before we get into our conversation with our guest, share with us some of something that you find really surprising that most people don't know about drug offenses.
Well, it's a really interesting and sort of unhappy reality. Shauna, suppose I were to tell you that if you hypothetically, if you had a family member arrested for possession of marijuana, suppose he's pulled over, the cops see a marijuana cigarette butt in the ashtray of the vehicle, and they arrest him for possession of marijuana. And when they arrest him, they find $5,000 cash in the vehicle. Let's say he just sold a boat that he had. If the police seize that cash for forfeiture, which the police assert it's related to the drugs, he would only have 30 days to file a claim to preserve those rights to get the money back. In this process, he would have to prove that money is not drug related, even if the drug charges ended up being dismissed. Let's say the traffic stop ended up being unlawful. They didn't have a proper reason to stop him in the first place. Mm-hmm. The law presumes that they get to keep that money unless he does the procedural step of filing this proper. You have to file this step within 30 days of that seizure of the cash. Mm-hmm. It's called drug forfeiture. Mm-hmm. It's something that Joe Marino is going to talk with us about. That's one of those surprising things. It happens all the time. Now, sometimes the money is drug-related, and they are allowed to properly keep that money, but it's one of those surprising things that innocent people sometimes have their money that's in the car or cash, sometimes even property, taken from them, and if you don't follow the procedural steps, you can lose it, even if it has nothing to do with the drug arrest.
Incredible, and we're going to learn so much more, but right now we have to take a quick break. Stay with us. When we come back, Attorney Joe Marino joins us to help us better understand more about drug offenses. Stay tuned.
I needed help finding a doctor.
PACE.
I needed help with my medication.
PACE.
I needed help getting around.
The Shirley Landry Benson PACE Center is a place that helps seniors remain in their homes, providing the care they need. If you or a family member are over 55 years old, you may be eligible for benefits offered by PACE. For more information, contact us at 504-835-0006. PACE, caring for those who cared for us.
Welcome back to the show, everyone. With so many people landing behind bars on drug charges, many question whether incarceration is really the best answer or whether the focus should be on rehabilitation. Joining us today is Attorney Joe Marino. He has years of experience in dealing with the court system when it comes to drug charges, and we are happy to welcome him back to the show.
Mr. Marino is a local attorney specializing in criminal defense in Jefferson Parish. He is a member of the Gretna City Council, a Kenner and Gretna Police Academy instructor, and frequent lecturer. Thank you, Joe, for being with us again. We're looking forward to continuing this excellent discussion about drug offenses and how people are impacted by it, how society is impacted by it with our jails really so overcrowded. I understand something like 60% of the jail population is non-violent drug offenders. That certainly accounts for a huge part of our taxpayer dollar. Is that your understanding?
That's correct. The majority are simple possession offenses.
Yeah, and so that's why people are looking at the question of whether incarceration is really the answer or if it really the focus should be on rehabilitation. And you sit on a sentencing board commission, right?
I'm on the front-end committee for the Louisiana Sentencing Commission. That's correct. And we meet monthly in Baton Rouge.
And is that an issue that you all are dealing with?
That is definitely an issue. It's simply just too expensive to incarcerate people, and it's when you're spending your tax dollars on incarcerating people as opposed to doing other things that might be useful to society, like educating people, or schools and hospitals and roads and streets. It takes a toll, and there's only so many dollars in a state budget.
Yeah, but in the meantime, people are getting arrested for drug offenses. So tell us, what are some of the typical situations of these drug arrests?
Well, I mean, in my practice, the majority of the drug arrests that I handle are people that are arrested in connection with a traffic stop. You have this expectation of privacy with regards to your home. That's your castle. But people don't understand that when you're driving around in your vehicle, you should either have a low expectation of privacy or none. When you get the easiest way to get arrested is to have drugs in your vehicle or be smoking marijuana in your vehicle. And you get pulled over for a traffic stop, they're going to smell it or they're going to see it, and you're going with them. And what if, and not what if, but when the officer says, "I'd like to search your vehicle," can you refuse? What should you do? Right. An officer can always ask you for consent to search your vehicle. He can always ask you if you have anything in your vehicle like guns, knives, or weapons or contraband that he should be concerned about.
Is that what typically happens?
It's usually one of the first questions that a police officer is going to ask you if he sees anything that alerts his suspicion. Like sometimes when people get pulled over, they may immediately start leaning over to the console to start grabbing the insurance paperwork or their proof of registration. Well, the officer sitting behind you in the car doesn't know the difference between you leaning forward and shoving and putting your hand in the glove compartment and hiding or obtaining a weapon and or something innocent like getting my insurance papers. So, if he comes up to your car and you're nervous and you've been fidgeting around, I mean, you should expect them to ask you for him to immediately start asking you questions about your behavior.
Well, I mean, it's a nerve-wracking situation, whether you have something to hide or you don't.
I get nervous when I get pulled over for a traffic violation.
Nobody wants to get a traffic ticket. I mean, maybe you didn't realize it. Maybe you were going a little bit over the speed limit, and these traffic tickets can be very expensive.
Right.
Right? So that's
back to your question, though, you always have a right to refuse. So if they ask for permission to search your vehicle, you can absolutely say, no, I'm not giving you permission to search my vehicle. And at that point, depending on the facts and circumstances of that particular case, what happens next is depending on what the officer sees, observes, smells. If he smells marijuana in your vehicle, or sees it, I mean, you would be amazed at how many people or how many arrest reports I read about a traffic stop, and in plain view they see some type of controlled substance, center console, ashtray, etc. And once the officer sees narcotics or smells it, he is going to go into your vehicle and get it.
And do they call it the plain view doctrine, if I'm remembering my law school education? So if it's in plain view, then they don't need a warrant. They can say it's in plain view. I see it's right there, so I can go get it.
And getting back to the Fourth Amendment, your right to be protected from unreasonable searches. There's an exigency factor associated with vehicles that's not there with your home. The officer can go and retrieve drugs, or when he smells or observes narcotics, he can search your vehicle without a warrant, because that evidence in that vehicle could easily be transported away, brought to another jurisdiction, or destroyed or gotten rid of when it's in something mobile like your vehicle. You're in a mobile crime scene at that point, and so when you're in your vehicle,
that's exactly
you should.
how the officer is looking at it, as a mobile crime.
That's how I try to explain it to people.
Yeah, and let me say this too. The police. You're nervous when you're pulled over by the police. I think a lot of times, and what people should also understand, well, I want to say two things. One, even though you're nervous and you're upset and you're hoping you're not going to get a ticket, and let's assume you've not done anything wrong, always be courteous to that police officer, because sometimes they have some discretion. Maybe you were going a couple of miles over the speed limit, but he or she might have the discretion not to give you a speeding ticket. If you have an attitude, if you're being rude and disrespectful, well, that officer might decide he's got a few extra minutes to write you a ticket that he doesn't, or she doesn't have to write you. The second thing I want to say is these are the same police officers who risk their lives every day for us, and will, and they may indeed save you or someone you care about's life out there on the roads. And there are criminals out there who are very dangerous, and they put on those uniforms every day, and so they deserve thanks for the very hard work they do, and they have the right to be nervous too, because
for your own benefit,
you got bad guys out there who might indeed be reaching for a gun, and I don't want that job, and I thank them for taking that risk. But that being said, that's why you don't make sudden moves, because
keep your hands on the wheel, sit still, and wait for the officer to approach.
And be polite, just like hopefully your parents or your grandparents taught you.
Correct.
Yeah. Let's talk a little bit about during the last show, we talked about the difference between distribution and possession. One thing that we didn't touch on in dealing with drug arrests is where you are arrested also factors into the charge.
That's correct.
Could you talk a little bit about that?
You'll see an obvious one would be in a school zone. If you are arrested for a drug possession offense, either on a school property, on a school bus, or within 2,000 feet of a school, the penalty is significantly higher. Whatever the possession offense is, whatever the ordinary range for that crime is, you're immediately subject to the maximum fine and up to 1.5 times the maximum jail sentence for being in possession in a school zone. That also expands out further to anywhere where there are posted drug-free zone signs, which can include any religious buildings. It can include drug treatment facilities. It can include public housing. It can also include daycare centers. So if you see that posted drug-free zone, you're looking at a range of 2,000 feet around that.
Wow.
Yeah.
And the penalty goes up, and you do go to jail.
So once a person has been arrested, what happens after that point?
Yeah, I mean, frequently that's when I'm getting a call. I'm getting a call from a parent or someone saying my son I got a phone call, my son got pulled over, he got arrested for possession of X. The first step in the process is they're brought over to the jail and they're booked, which is the identification fingerprinting process. They're going to do a criminal background check. They're going to get information ready to present to the judge. The judge, after the booking, is going to set a bond for each and every crime that you're charged with. After the bond is set, there are different ways that you can post a bond to be released from jail, meaning you can pay a bail bondsman 12% of the amount of your bond. You can put up a property if you own. You can do a property bond. You can always pay cash, a cash bond, which is rare. But the better solution, if you are like a first offender charged with a nonviolent offense, is to try to be released upon a signature bond from a family member or a friend.
Or they
sign guaranteeing your appearance in court and agree to owe the money to the court in the amount of your bond if you do not appear, and do not appear within 6 months of them receiving a notice that you didn't appear.
Does that happen pretty often?
And no money needs to be put up in that circumstance.
No money needs to be put up in that situation, and that happens with regards to overcrowding situations. Aside from all of those options, if the jail is actually full, the nonviolent lower class offenders are going to be released on their own signature on overcrowding first, to make room to put people that they need to keep in jail.
Okay, all right. Well, we have lots more that we want to get into. Plus, we want to get our viewer questions in for you. We have lots of those. So when we come back, Attorney Joe Marino takes your questions. Stay with us.
My life is full of statistics. Thing is, I could have dropped out of school and become one myself, but I didn't, because I had people that believed in me. Here's another statistic. 7,000 students drop out every school day. That's one every 26 seconds. It's time that students know that we believe in them.
Inspire a student and share your message of support at boostup.org.
Welcome back, everyone. Our guest today is attorney Joe Marino, and we are talking about drug offenses. Now, you all have sent in some really terrific questions, and he is ready to take them. So we're going to start. Our first question comes from Jake. He says, my attorney said that I will only be charged with a misdemeanor even though I had 20 pounds of marijuana on me. Is this true?
Well, your attorney may be under the influence of marijuana telling you that. Possession of 20 pounds of marijuana is more likely than not going to be charged with possession with intent to distribute because of the weight. In order to be charged with possession, it has to be consistent with personal use.
Okay.
And 20 pounds is a very, very large amount of marijuana. And I have seen cases, and I have actually had trials before where you're talking about a smaller amount, and the issue is that for personal use or is that intended to be sold?
Well, that brings us to another question. This one is from Barb. She says, my cousin was arrested for having 2 pounds of marijuana in her home. Why was she not charged with possession with intent, but the guy in my class was charged with intent for having 1 ounce in little baggies?
Right. It's easier to answer the second part of her question than the first, because on the first end, you know, that first person with 2 pounds, they may be cooperating and working with the police for all you know. It's hard to speculate. But with regards to the second question, with intent to distribute, they're looking for evidence that it's going to be for sale and not personal use, like packaging, the small amounts in small bags. The weight is another factor that they look at, the overall weight. Any officer observations for possession with intent to distribute? Did it look like a hand-to-hand transaction occurred between a person and a vehicle before they approached and found this? Does the person arrested have a large amount of cash in small bills, carrying multiple cell phones, a weapon? They also look for evidence of personal use. I mean, does the person arrested even have a pipe or rolling paper when you're talking about marijuana? But they're looking, the difference is what is intended to be sold and what is for your own personal use. And sometimes that's the jury question in a trial.
So the guy or whoever there was that had 1 ounce of marijuana, that's enough for, I don't know, that's like, I don't know, 20 or 30 marijuana cigarettes. That might be enough for just one person's personal stash, or one person, but because this person had it all individually, had it broken down into individual packets, that appears to be like they're packaging it for sale. That might explain why it looked like it was
and
being prepared for individual sales.
Some things go both ways on that, because I've also represented people that were charged with possession with intent to distribute because they had a bag of marijuana and they also had a scale. And their explanation was, when I buy it, I want to weigh it, just like the guy who's selling it is packaging it in certain amounts. But it's absolutely on a case-by-case basis, and you have to look at the totality of all the facts. And also, one that I didn't mention from before, does the person who was arrested have a previous history, a drug history for selling or distribution? That's a factor that the police and the district attorney are going to look into to decide whether or not they're going to charge you with possession with intent to distribute or simple possession.
Something very interesting that you mentioned not very long ago, outside of just being arrested for having the drug, the illegal drugs, you said the paraphernalia also factors into the charges as well.
Right. I mean, if your defense is that it's for personal use, then you would expect to see something that would be associated with that, like a pipe, rolling papers, that type of activity. Even with heroin, I mean, people inject heroin with needles. I mean, if you're arrested and you have a bag that has needles in it and you have a strap that you'll put on your arm and things like that, that makes it obvious to me that that's more consistent with personal use than with selling. But then you also have that crossover category of some people who are selling to support a habit. So they're users and selling to support the habit. And that again, everything is going to be on a case-by-case basis as to how the district attorney or the courts proceed with that.
Okay. We have a question here from Sue, who says, my son was in a vehicle with a friend. It was his friend's car, but my son was driving. The police pulled him over and smelled marijuana and arrested all of them. Is there a way my son can get out of this?
You know, again with that, you know, the questions that I'm gonna be asking them would be, you know, where was it located? Did anyone make any statements? What are the police officers' observations? Was there any indication of recent drug use? Because the officer can pull you over, smell marijuana in the car, and you get out of the car with red, bloodshot eyes, and you smell and look like you've just smoked marijuana, even though the guy sitting in the car with you is the one holding it. You can be charged with possession with that as well, even if it's not on your person.
And does that, I mean, that applies to, let's say they have friends in the back seat. I mean, all of them could potentially be arrested, right?
Well, and sometimes that happens. And other times the person who, or not on someone's person, they find it somewhere in the car, underneath one of the seats. Unless somebody's going to claim or take ownership of that on the scene at that time, it's possible that everyone could be arrested who's within, I would say, arm's reach of it.
Wow.
Interesting.
We've had a lot of questions about marijuana. If you change the hypothet and it's a little baggie of cocaine or heroin or whatever, it's the same thing, except the charge is going to be a felony.
It starts out as a felony, that's correct, even a small amount. Possession of one piece or rock of crack cocaine is a felony.
Is there a difference whether it's white powder cocaine and crack?
Not in the state system. In the federal system, there's some different sentencing provisions, whether it's in the form of crack cocaine or powder, but in the state system, cocaine is cocaine, whether it's powder, crack, or any form.
They typically end up in the state system, though, right?
Well, the federal government prosecutes cases and the state, but I mean, mostly what I deal with are state offenses, and most arrests are going to be in state court. The majority are in state court, not in the federal court.
If a state trooper pulls you over, does that make it federal, or it's all state?
No, generally, when you're dealing with drug offenses that are in federal court, it's going to become, it's something that involves something that's crossed state lines, or multiple parishes or jurisdictions are involved, and your bigger conspiracy type cases or federal court type of cases. State court is the majority of where cases are handled and prosecuted.
Okay. Well, it seems like just about all of our questions are about marijuana. I don't know what that says, but we have another question from Blake, who says, I have my first marijuana possession charge expunged, or I had rather it expunged years ago. Does that mean if I'm arrested for simple possession again, that it will appear as if it is my first offense?
Right, and I think I mentioned that earlier, that a possession of marijuana second offense, the district attorney's office makes the call as to whether or not they proceed in charging you with another misdemeanor offense, but you can also be charged second offense possession of marijuana under the statute is a felony, and there's no time limit involved. Like with the DWI, there's a 10-year cleansing period before they can up it to a second where you have a higher penalty. None exists for that drug.
Politically and socially, it seems like that many parts of the country are really lightening up as far as their views on how bad or evil a drug marijuana is. 2 states now have decriminalized it, at least in smaller quantities. And there have been polls conducted where many people appreciate that marijuana has benefits as a medicine to treat various ailments, including glaucoma and cancer. Do you see any trending in that direction, including in the panels or the committees that you're sitting on?
I mean, one of the things they're looking at is to decrease the penalties or the felony versions of marijuana in particular. I mean, you have to remember that the way that they set up the statutes, marijuana is listed as a Schedule I drug, which is in the class with heroin. Okay, Schedule I drugs are drugs that have a high potential for abuse, no currently accepted medical use in treatment in the United States, and a lack of accepted safety for use of the drug under medical supervision. So it doesn't fit there. There are medical uses for marijuana in the United States, not in Louisiana. So just the fact that marijuana is still a Schedule I drug, I believe that's wrong. It's incorrect. And
is
marijuana.
there anybody advocating that it should stay listed as a Schedule I drug? Any respected advocates?
It's kind of all over the board. I mean, you have Schedule I drugs like marijuana that can be a misdemeanor, which are these supposed to be the most serious type of drugs, and that is a misdemeanor version of it. Then you have some drugs that are listed in Schedule II or Schedule III, which have a more severe penalty than a Schedule I drug, and it's kind of all over the board, and there are a lot of exceptions for different drugs in particular. But you know, obviously, in my opinion, I don't believe that marijuana is any more serious a drug than alcohol.
We have another question here from Luke. This is something that we touched on, but I think it bears repeating. He says, if you can get charged with distribution, even if no monetary exchange takes place, what if someone steals my drugs? Can I be charged with distribution then? If you could just explain again distribution and the fact that it doesn't really have to involve the exchange of money.
Right. I mean, that's entirely correct. It's, people are typically telling me, well, I didn't sell it. I gave it to him. I didn't sell it to him. Well, that doesn't have anything to do with distribution. A distribution is a transfer from one person to another. I give it to you. I've committed the crime of distribution of whatever that drug is. Like the other example I used, even with your mother giving you her prescription medication, which seems pretty benign and not very serious. Well, your mother is just committed the crime of distribution of a legend drug when she gives you the rash ointment for poison ivy. So that's another example of over-legislating, in my opinion, and trying to attack a problem the wrong way.
Wow. Well, we appreciate your time. We are out of time. We have learned so much. Thank you very much, Attorney Joe Marino. That is all the time that we have this week on Power of Attorney. Thank you for joining us. Be sure to join us next week when we'll take on another hot legal topic. And as always, we will include your questions.
And you can send those questions to us via Facebook, email, and Twitter. Also, visit our website at johnredmannpoa.com for more information and links to everything on today's show and past episodes. Thanks for watching. We'll see you next time.